All right, so I'm Andrej Milic. I'll give you a little introduction of who I am, just so you know. Why is this guy from the law school talking to us? Like, why do we even care about legal issues? We're creatives. Most creatives hate dealing with the legal side of it, right? It's like, when you buy a new piece of software, a new technology, and you have to do I accept all these terms and flick through it. How many of you actually read that? Nobody does, not even lawyers. They just click wrap it and they go on next, right? So why am I here to talk to you specifically? Because I grew up in the creative space. My dad is a visual artist, he's a painter, and my mom is a crafter. She makes yarn inspired products. So I grew up in a very hippie, artistic household. And how did I end up being a lawyer? Well, that's a very long story for another day. But I totally understand the creative space. And one thing I wanted to talk to you about today is how to protect yourselves against the pitfalls, right? Because the legal area is a little scary. It seems very convoluted. For a lot of creatives, they're like, how do I even deal with certain challenges when it comes up to either selling or marketing or exposing my work? And also in my role as a development officer, all that development means is fundraising or advancement, as a lot of units call it, is how do we bring in money, right? Like, how do we bring in money for projects and things that we're interested about? So I'll talk about legal, I'll talk about fundraising, and that way hopefully you'll walk away feeling a little more at ease about the legal aspects to what you're doing, and feel a little bit better about also how do you monetize your creative capital, okay? So my education is mostly in South Florida. I went to school at Miami-Dade College, did my bachelor's there, and then went and did my master's in management at St. Thomas University, did my JD, my doctorate at University of Florida, and then did my LLM at St. Thomas in intercultural human rights. And I've got a background working with immigrant communities because I'm an immigrant myself. I come from Austria. My parents fled communism in Yugoslavia, went to Austria, had there, and then I grew up in the United States. So even though I don't sound like it, I'm not an Arnold Schwarzenegger type, I guess. I'm sorry to disappoint you, because I'm not going to talk like this, right? But I lost my accent somewhere, I'd say, on the trip over to the US. But definitely, I have a certain perspective that's a little bit unique from my standpoint as an attorney and as somebody who works with FIU College of Law. So some of the things you want to be mindful of as a creative is exposing your work, right? Like, you want to protect your work, you want to be able to market your work, but more importantly, you also want to be the one that is going to be able to profit off of the hard work, whether it's the intellectual property or whether it's the marketing, licensing, and branding of your work. So how many of you produce a physical product? Okay, so what kind of physical products do you produce?
Postcards, wallpapers, prints,
Okay.
and also with modular. I actually have a patent on that system, this plastic modular system.
Very good. So posters, modular systems, something tangible you can hold. Who else? Who else said that they have physical products?
I have ceramic ware, such as dinnerware, cookware, and office.
Okay, so ceramic products, utilitarian pieces, decorative pieces, things like that.
Sculpture, paintings, fine art.
Okay, sculpture, painting, fine art.
From material, formula to object to electronic product to sculpture, art.
Very cool. So what are some of the concerns that we have when we're producing tangible goods? Is that somebody's not going to take our idea, right? That they're not going to produce the same thing, that we can monetize off of our goods and potentially even license the ideas. I feel like a lot of creatives where they have something that's really interesting, like they make a modular piece, and that modular piece may cost $10,000. How many people in general society will be able to afford that piece? Very few, right? If we think about that in that scale, some creatives want to say, okay, well, I want to have it accessible through IKEA. I want to make it, my originals will be 10,000 and up, but my mass-produced products will be, slightly different design, but I want to have them released by a large company. Well, how do you get from your concept to then that large company producing it is usually going to be licensing agreements or royalties, right? So you're starting to look at how do I leverage what I've created, and I'll bring up some case studies for you. Case studies are just things that have happened in the real world that are artists and creatives that have made money off of their products, not necessarily selling their originals so much, but merchandising and branding their original. So how many of you know Guy Harvey or have heard of Guy Harvey? Like the t-shirts with the fish, right? So Guy Harvey made a lot of his money selling t-shirts. And those t-shirt designs started getting a lot of traction with certain festivals and started being mass produced, and also started tapping into a local market of this tropical island life. And that's really where the artist made the money, the original artwork. How many of you have ever seen an original Guy Harvey painting? But not very many, right? Maybe one or two people. You don't really see it as much because that type of creative can hold on to their original pieces, but then mass produce something that can generate a lot of revenue. But also, let's say, for example, Guy Harvey designed one shirt and 30,000 pieces are sold, and he makes $2 per shirt. He just made $60,000, but did he have to make all those shirts? No, right? He just had to protect his design. He had to make sure that the licensing was done right, and that perhaps, you know, he sold the rights of that shirt for a certain set amount to somebody that's producing. So what's better, a licensing agreement or to sell the rights? That's something you also want to think about. Should I sell that design completely and let a company run with it and say, okay, well, you'll pay me 50,000, maybe you'll make 100,000, maybe you'll make less, but I'll take that? Or should I take a cut of every single piece sold? And that's sometimes what you want to think about is what kind of agreement am I going to have with a manufacturer, with a producer, with somebody who's got scale to, you know, to distribute it and sell it, and what kind of control do I want to have over my image, my, you know, production, and how do I see myself maybe potentially monetizing it? And for a lot of creatives, the conversation of monetization creates a very unsettling feeling, because it's, you know, as a creative, you want to create art and you want to produce it and you want to make it available to the world, but then when it comes down to like, okay, how are you going to monetize it? That can be a pretty hairy conversation, because you're like, well, I didn't really think about that. I thought about the benefit it will have to society. So I challenge you to also think about when you're creating a product, whether it's tangible or intangible or an experience, how are you going to generate revenue from that? And who's going to benefit from it, right? Because it just doesn't have to be you benefiting. It could be a non-for-profit benefiting, in addition to a corporation benefiting, in addition to a community benefiting. So you always want to think about who are the stakeholders, who are going to benefit from this? Do I want to have also a philanthropic angle to my artwork? So for example, Xavier Cortada, who is a former lawyer, but artist, I don't know if you remember, Under the Overpasses did all this ecological awareness work with the mangroves, and did a project where local businesses were growing little mangrove pods in the windows and cups of water, and then we're planting it. He does a lot of work. He's a former lawyer, doesn't practice any longer, but now does work with art and medical organizations, ecological, but does a lot of partnering, right? And why is he so successful in the partnering side of it? Is because he has a legal framework that kind of looks at who can benefit and how many parties can benefit by utilizing my ideas and my creative, you know, vision. Like, for example, a local artist that is a really good person at partnering and branding is Romero Brito, right? So Brito takes his artwork, you may like it, you may not. It doesn't really matter, he makes a lot of money from it, right? He has a lot of marketing and co-branding. What are some of the things that he does to make money? So prints, you know, luggage, swag, shirts, but he also sells like a series of sculptures in partnership with Disney, and does basically he licenses their intellectual property to be able to use it to sell it in his stores. How did he get his products out? So he was an artist that was selling on Lincoln Road 30 years ago. So anybody who would walk by and purchase his pieces. So how does he go from that to being somebody that's selling millions of dollars of art every year? It doesn't hurt to have the Kennedy and Shriver family behind you, so that really helps. So donors and champions. You are the creative. You want to have people that are championing your artwork. Let me ask you a question. When have you purchased something that somebody else told you this is amazing, you gotta buy it? Have any of you ever had that experience where somebody else tells you this is amazing, you gotta buy it? Do you buy it because you trust them? Do you buy it because you're curious? What are the reasons you buy it? But oftentimes people will buy something because somebody else tells them to buy it or says like, I really love this. You may buy it and you may see like, I don't really love it as much as they do, but, or you may say, yeah, you're right, this was amazing. But oftentimes we trust the opinions of others. And in the creative space, many people purchase, like, for example, we did a legal event, we had an artist from Cuba that just came from Cuba here. Spray painting and creating original pieces. Within 3 hours, I believe sold 20 or 30 original pieces, mostly from the recommendations of the lawyers that put together this event for human rights in Cuba. If that artist did not partner with these professionals, and this particular day session conference would not have sold the 30 original pieces. And probably if the artist on his own was trying to sell these pieces, would have a much harder time without a known name, being new to the country, selling these pieces. So sometimes you can sell your products or your creative output based on a certain event or a certain venue, or the support of a certain community, right? Like oftentimes at charity events and galas, there's auctions that happen, and those auctions will include, pieces that, for example, one thing I used to do with my dad's artwork is I would set up a charity auction with just his artwork, and half would go to the charitable cause and half would go to him. So people that were purchasing it to help the charity, but the half that went to him was still enough to cover his expenses and make a profit on it, right? Would those people ever have bought his pieces or not for that? No, they wouldn't have even known about them, right? So you got to think about exposure to being known, and you got to think about also what are the threats as I expose myself more. So as I use social media, what are the chances that somebody's going to rip off my ideas? Well, you leave yourself exposed because you can't protect the viewers on social media from not copying your ideas. But where you have an advantage is that you're growing a community that understands who you are and what you do, and a following that is much more powerful because you're building the strength of your brand and who you are, and you become synonymous with that. Where when people try to copy it, it's not really who they are. It's not their true authentic expression, right? And you really can't prevent somebody from like one thing that happened with my dad's artwork is at some point somebody tried to put it on tote bags and sell it online, right? And we sent out cease and desist, but when we really looked at overall revenue, like you're like, oh, well, somebody's taking the idea and trying to profit off of it. They created a lot of his clients were like, oh, they shouldn't do this. This is not nice. But when you really looked at overall sales and how much it made from it, it was so minuscule. It wasn't even worth suing them, right? So if you look at if somebody takes the idea and tries to run with it, they don't know how to profit off of it. It's not even worth litigating, right? You got to look at any time where litigation is going to get involved, it's going to go after deep pockets. So if somebody did take your idea, let's say, for example, you made a sculpture and somebody stole that sculpture idea and mass marketed it and sold it through CB2. And CB2 made all this money. Well, CB2 is a deep pocket, right? And it was your intellectual property, then yeah, it makes sense to go after and litigate and sue to get some of that compensation back because they profited off of your idea, off of your creation, right? But oftentimes with creatives, they're like, well, I'm going to sue somebody for taking my idea. Well, first of all, you got to think about, did they make money with that idea? Does that person have money for you to get? Because you're never going to sue somebody who is not liquid. You're never going to sue somebody who can't pay you, right? Because the problem with that is you're the one left holding the bag. You're going to invest a lot of money in a legal team that then it wasn't even worth it, right? So you always have to think about, keep my ego in check when it comes to, legal actions, because is it really worth it in the end? Also, when you think about, for example, non-tangible artwork, like some people, they have like digital experiences or, something that is not a product you can hold. it may be a piece of music, it may be a production, it may be like, you know, when you saw the Van Gogh experience, like projections that people go and experience. You know, that's a little bit different. And it's like, how do you monetize off of something like that, where it's not a product that you're providing, but an experience? Oftentimes it'll be off of either, you know, you're benefiting off of an entry fee, or you're benefiting off of some sort of grant that you're getting to provide it for free for the community. But you want to think about, how is this going to monetize for the longevity of my creative work? Because if you're not making money with your creative work, sometimes you may be getting really big marketing in return and it may be beneficial to you, but how long can you sustain yourself if you're not monetizing, right? So it's not about like, oh, I'm going to make $1 million with my idea, but how much would I need to make out of this idea and out of the following ideas to keep my work going, to continue to provide. So what's your name? Victor. So Victor and I were talking, and Victor's got some amazing ceramic pieces, right? But I was also telling Victor, like, here's an interesting idea. So you produce ceramic pieces that are in the hundreds of dollars, right? And could go up to the thousands of dollars. But not everybody may have a budget for that, right? But where's something where you could have, so one of the things that I've seen in just like my experience is that in a lot of specialty shops, gift shops, which the Frost Museum, I just met with them, they're actually putting together a gift shop. How many of you knew the Frost Museum is putting together a gift shop? So very few, which is good because I'm exposing you to new information. How many of you would like to be sold in that gift shop? I imagine all of you. Those are conversations to start having with the Frost Museum, and how can we support our students and alumni in making money? How can we support us having our creative work from the university exhibited in this new gift shop space? How can we contribute? So for example, when I travel oftentimes to museums, there's a very neat museum I went to, I think it was in Indiana. They had ceramic flowers, and each flower was like $30. So we bought a vase and we had like multiple ceramic flowers. Very low lift from a ceramic standpoint, beautifully glazed, but something that's really unique that we took away. Also environmentally conscious because you're not cutting flowers to now put them in this display on the table. Everywhere you go in a gift shop, Christmas ornaments and magnets are sold. Why not have them out of ceramic, where it has a unique glaze, and on the back of that piece that may be going for $9.99 or $29.99, it gives the information of the artist. So what did you just do? You just made a royalty, but you also got a ton of marketing out of it. And the store that is selling it, or the gallery or the museum, is showing their commitment to local artists. So who would say no to that, right? And let's say, for example, you make one magnet design, you can have it mass produced and make millions of dollars if it's a very, you know, high volume city. Like let's say you make a New York magnet that everybody wants, and they start seeing it at all these gift shops, and it's sold for $9.99, but you're getting $1 out of every magnet sold. How many visitors, if you all have a phone, Google, how many people visit New York a year? How many tourists come to New York a year? 5.2 million. And I guarantee you every single one of them buys something, right? So as creatives, I challenge you to start thinking about, how do I leverage what I do? And how do I make it accessible? Because one of the things that's difficult, and coming from a background with a visual artist, not everybody can afford to buy an original piece of art. It's not part of their budget. Maybe it's not part of what they can afford, but everybody can afford a magnet, a keychain, something that allows them to feel like they're not only contributing to your career, but that they're also starting to make steps towards being an art collector, to being an art supporter. Because for a lot of people, they feel like I could never afford to be a supporter of yours. And if you give them an entry-level item, if you give them an easy cost of acquisition where they feel like they're part of your success, you can actually start converting. And that's where philanthropy and the things that I've learned in philanthropy become very beneficial, because for a lot of individuals, we start with very small amounts. But when you break that ice, that small amount can turn into a $9.99 magnet, can turn into a $500 bowl, right? Or that $9.99 keychain can turn into $1,000 sculpture. But you start allowing the customer to feel and experience a piece of being part of your success, and they have a vested interest in your success then, right? And then that's where you really get the loyalty from the following, where people are not gonna wanna purchase the knockoffs. They want the original. Like, how many of you would rather have a knockoff pair of shoes? Well, except for the one exception, right? If you had to choose, right? If you had to choose between the original product or a knockoff, most people feel really good having the original. And they don't feel so good in having a knockoff. And that's something in today's society where, you know, people want to have an original Victor, or people want to have, you know, an original piece that Mariana is producing or that somebody else is producing, that they can feel, you know, proud that they're part of your success. And that, you know, sometimes people will buy your creative product just because they want to support you and they like you. They may not understand art. They may not understand ultimately everything you're trying to do. And to them, it may just be like, I really want to support your progress.
I have a question though, so, I'm wondering, because we don't.
No, there's no, it's just
It's just for them, just.
It's just for the
Okay.
video.
I'm wondering though, so, I understand that like when it comes to artists, it makes sense, you know, to support them, you know, and kind of what they're going for, but I feel like that could be lost in translation when it comes to some companies. So for example, there's this company, I don't know if you're familiar, for example, Golden Goose, right? They
Yeah.
make these really nice sneakers, they're like $700. Now there's another company that's called Oliver Cabell, also makes shoes that are very similar, also made in Italy, but they're like 40% less, you know? So I think when it comes to situations like that, like personally me, I wouldn't mind having the ones that are like, you know, 40% cheaper because they're still made in Italy, it's still good quality. I think sometimes I feel like when it comes to brands, what you're paying for is the brand, sometimes not necessarily the quality. So I think it varies. I think you know, big companies, designers, because it's not really the designer designing anymore. It's like, you know, a whole factory working for them, as opposed to, you know, when there's a single artist and they're making it, of course you're like, I want to support them, you know, and see kind of their vision flourishing and, you know, them reaching their creative aspirations.
But it can also depend on, for example, there's going to be nuances and differences, and some companies have very similar products at different price points. But in certain ways, like even if a company has a similar product or offering, you got to think about, why would my community stay loyal to me even though I'm more expensive? And that's the value that you bring to them. So maybe you're bringing a value that, hey, they're buying this shoe or they're buying this, you know, jacket or t-shirt, but they know that it's tied to sustainability. Where if I don't, let's say for example, I'm a vegan, and I know that you as an artist use products that are not harming animals and that are eco-conscious, even though somebody else is producing something that looks similar, I don't know and I don't trust that they're going to do the same thing. They may claim that they do, okay, but you're building the trust in the sense of, my products are guaranteed to be, you know, renewable or reusable or upcycled. And we've built that trust where when somebody else comes into the market and tries to offer something similar, I may not have that trust with that. And there's always going to be a portion of the clientele that will splinter. Like for example, with you know, any creative product or any creative experience, you're always going to have people that are trying to get a segment of your market, right? In similar ways. So you want to be mindful of, you know, how can I keep the loyalty? How can I ensure that I'm building community and that I'm building support? Because oftentimes in the creative space, it's not about the final product, it's about you and your process. And letting people into that process, they want to be part of that. Because most of the people that are supporting artists are not artists. They're people that are, you know, working. Maybe they gave up on their artistic dreams, or maybe they never had any artistic talent, but they really appreciate what you do and how you educate them about what you do. Because in a lot of ways, Like before I talked to Victor, I didn't know about his glazing technique and why it's so interesting. Like you have to do your job to educate on why is this unique and why would I rather buy this than a mass-produced piece of ceramic that had no forethought or consciousness that went into the glazing or the way that it's produced, right? So you want to be able to also educate the public and this is why I'm bringing value, or this is the value I'm offering, right? That it is something that has a thought process behind it, that has some meaning, that has a positive benefit to society, or that is to be revered and put up on a level where it's more expensive or valued higher, or something that I want to make an investment in rather than going and buying something that's mass produced, right?
I think that sometimes though, like with big companies, for example, like my mom works in fashion and she works in kind of like manufacturing, so she responds to, she meets with designers and stuff, and they kind of tell her, we'll want this line produced and this, she's kind of responsible for like all the threads, all fabric, and kind of putting the whole thing together. But what she says is actually that sometimes like the known designers, and I think this is also maybe a little bit of a different conversation of, like the really big companies and artists, like I think that's like there's that big separation between that.
Yeah.
But for example, the designers, they'll actually, the more well-known ones, they're actually like sometimes not even choose to like produce with my aunt in Europe. They rather go to like other countries where it's cheaper to produce because they want to increase their revenue, 100-fold, like it depends on the designer.
Yeah.
So I think what you're right, when it comes to artists, like I think it's different when it versus just acting as like more singularity, as opposed to when it's like huge firms and there's like 500 employees or even thousands of
Well, because
employees.
you're balancing interests. So sometimes you've got large companies that what's their interest? It's in making as much money as they can with the least amount of expenditures. Your interest as an artist, maybe money and profitability is not very high on the scale, which is okay. But at some point, it needs to be part of the conversation. Or like a lot of artists get excited about what they're doing and a lot of creators get excited about it, but then they forget the part of how are we going to monetize this? How are we going to monetize it together? You as a corporation, maybe there's something that I don't see from your corporation that you can utilize my product in to be able to bring awareness to maybe a specific cause or to help build support for a particular charity. But how are we both going to benefit from this, right? And that's the conversations we start having, that you may not know what the final outcome will be, but by starting to stir those conversations and seeing like where could this lead and how could this generate profitability, that collaboration and that cooperation will start opening new avenues that you didn't even think were possible, right? That it's important to start looking at, do we go to another market and mass produce cheaply, or do we keep it a limited number, or do we have a certificate of authenticity that goes with each one, that it's a limited series? Anytime anything is limited resource, what does that mean for the value? It goes up. Does that mean that that piece is necessarily worth more in reality? Not necessarily, but to the consumer, it's something that's exciting. It becomes limited. Not everybody can have it. I want it. I'll pay more for it. So for example, right now we have the finals for the women and men's basketball. The women's tickets are double what the men's tickets are right now. Why? Because the women were put in a smaller venue. It was anticipated that there would be less demand, which was wrong. And now their tickets on the secondary market are double what the men's tickets are, because they did not understand where the demand was going to be. And in that error, now the secondary market is going to make a ton of money off of reselling these tickets that are very popular, because some of the best women players are going to be playing in this finals, and then they'll go on the WNBA and never play again, right? So when you build demand and that desire for people to have your creative output, that's where a lot of value can be created. Why did the artist from Cuba that doesn't know anybody here, that doesn't speak English, sell 20, 30 pieces in a matter of hours? Because there was a demand. This artist will be here from this time to this time live producing pieces, and will bring a portfolio of pieces and highlighting Cuban human rights at this event. How can we support somebody that's actually fleeing this regime, that is a creative that's coming into our country? How can we help them get a fresh start, right? would have people bought his pieces if he just set up on Coyote and put them out? Probably not. They didn't know his story, they don't know who he is. And there was no urgency to buy them because maybe he's there every week or whatever, and people don't necessarily get it. So your story about your pieces is very important because you're not just selling a product, you're selling a piece of yourself, right? Like, why would somebody choose you over somebody else? Why would somebody choose, to buy your shoes over somebody else's shoes? It's not just because they can get a similar design from somebody else, but they feel unique, they feel special by buying yours, right?
So we're talking a lot about building trust and
Yeah.
marketing the artwork or
Absolutely.
the digital writing that we might be doing or any of that. So what if you've done all of that successfully? You have a community that loves you. You're selling your items and maybe you're donating to charity, you're doing all this stuff.
Yeah.
How do you do the baseline necessary legal stuff to make sure that it's not swept out from under you? Because I don't know if you're familiar with the artist Alex Morris, who does these little comics, and every comic ends with, "Oh no," and that's like his tagline, and he got really popular for his tagline. And thankfully, he did copyright his tagline. But this year and last year, he's been publishing a lot because of like posts, because two different companies have tried to sweep out that tagline from under him, hoping that he do think to copyright it and then steal it and block him from using his own tagline in his work. So he's been embroiled in legal battles for years.
Yeah.
Thankfully, he has the copyright, but what's like the baseline that artists should do beyond
So
their?
the first thing you should do is, as soon as you have that revenue generated, is start investing and protecting intellectual property. And that's where a lot of artists make a mistake. They start making a lot of money and then they're like, I don't want to pay for intellectual protections. I don't want to trademark, I don't want to copyright. I don't want to pay for legal fees associated with that because it's expensive. And it was really hard to make my money. So I don't want to put that as an investment. You have to, because if you're not protecting it, it's very difficult to go into court and say, well, hey, this person stole my idea, and prove that they stole your idea and be able to then get compensation based on that idea being stolen. So oftentimes, if you have the copyrights in place, which it costs to file, it costs to litigate, like just because you have the copyright doesn't mean that that other person or that other company that's taking your idea is gonna abide by your cease and desist. So you give them a cease and desist, you say, hey, stop using my intellectual property by this date, or we will, sue you. The issue is that you also got to back it up, because there's a lot of people that send out cease and desist, but then they don't want to litigate, right? And they do it as a tactic to try to scare others to stop. But then you also got to look at the profitability. So, okay, these two companies stole his idea of, oh no, that he copyrighted.
And then they sued him.
Yeah, well, that's different, right? That's an aggressive tactic for them to then try to intimidate him, and that can happen sometimes, but it's very rare because litigation is very expensive. It depends. Companies can be very large. I saw a scenario of a creative that had a company that actually got sued by Intel that approached me and said, hey, what should I do? And I was like, honestly, they're sending a cease and desist. You did use part of their copyrighted material in your company. The easiest thing to do is change your branding and they'll leave you alone, right? So at that point, sometimes if you're in the wrong, the easiest thing to do is stop what you're doing and shift and create a new idea where you're still able to run with it, still keep your clients. Sometimes you can't protect from litigation, right? But what happens if you do get sued? So how do you avoid it from getting worse? Well, there's some creatives that they will inflame the litigation. What does that mean? So somebody gets sued and you say, oh, you know what, screw you, I'll see you in court. I don't care, I don't want to negotiate. Well, that becomes very problematic because now their legal fees are increasing and they may be right. And you're not coming to the table to try to negotiate or bargain or do anything. And oftentimes, when it comes down to it, if you can figure out some sort of solution, it may be like, hey, you know what, we're not going to go to trial, we're not going to go to court. Well, let's figure out maybe a partnership where we're both profiting from it. And maybe you're sharing part of the revenue that you're bringing in, and it may make sense. It may not make sense to do that. And then, like, let's say, for example, you're licensing your material to a company, and that company, is not paying you, and you got to sue them to recover what's rightfully yours. There can be many legal situations that come up, but you also want to think about, how do I prevent the cost of you know, the legality from getting worse. And how do I protect myself in the beginning? So by having your intellectual property line and filed, like let's say, for example, you're doing a modification of a pre-existing product, you want to have a utility patent, right? So you want to have a utility patent for whatever you're designing in place, that if somebody rips it off, you can sue them to recover, because they may be a large company that profited millions of dollars and you didn't. But now you can, you know, either sue them or send a demand letter. Or now you bring them to the table and maybe they say, well, you know what, you were right. What would it take to settle this? That's something I'm thinking about. Let's go there. Mm-hmm. Mm-hmm.
I understand. And if we have to.
Yeah, so when you're doing a digital experience, it becomes a little bit more challenging because you really have to be as accurate as possible in describing what is the immersive experience that you are protecting, and how do you be as granular about that, making sure that you are not leaving yourself open to people knocking it off, but that you're able to and that's the challenge with the digital side of it, is being as accurate as possible, because it's more abstract, it's more intangible, so it becomes a little bit more difficult. But if you do a good job at verbalizing what it is, and that may be actually like working with somebody that is a writer or somebody that can help you get into words what you have created and properly describe that, will make it a lot stronger. And also it will come to like trade dress, for example. Trade dress goes down to even websites and digital experiences. How similar are they, and how likely is the public to view them as being, you know, knockoffs of one another? And there's like a fine line with digital, where if you start looking into like trade dress litigation, it's very interesting in how those cases go, because sometimes they're seen as, you know, violations and sometimes they're not.
You address some of the differences in terminology between something like copyright, when it's applied, trademark, and patent, and the difference between a design patent and, for example, a utility patent, you know, and I understand perhaps that a patent can actually apply to something like a process, which could include a service or a sort of process for creation of something like a digital experience.
Yeah, so anytime, for example, like you've got a lot in the realm of intellectual property, and I'm not the expert in IP filings, or there's actually lawyers I recommended to come and speak from the US and Patent and Trade Office that can talk to you exactly about what's covered and what's not. But when you think about processes, that's usually what you're looking at when it comes to a patent, because there's steps you go through that are going to distinguish one patent from another. And oftentimes patent applications are rejected initially. Why? Because those processes are not descriptive enough. You cannot have such a broad patent. It doesn't benefit you to have such a broad patent, because you really want to be nuanced and protect yourself as closely as possible to what you're doing. But then when it comes to utility patents, those are a little bit scrutinized less. Why? So why would a utility patent have a little less scrutiny? Is because they're usually a modification on a pre-existing patent, right? So you're looking at the hard work was already done on the initial patent. This is a add-on, an addendum, ex post facto type of modification, and we already have the heavy lifting done early on. But in the IP space, where a lot of creatives fail, is that they think they don't need it at all. They figure nobody's going to take my idea and profit off of it. But you always, like I say, don't be paranoid, but be mindful. And you also have to be realistic. There's some creatives that think every idea that they have is $1 million idea, and in reality, it's not. And it's not. It may not be even profitable. You got to think about, how can this idea be profitable, and how can I protect it from somebody taking it and running with it and me not having my protections in place. And, you know, a lot of creatives may have a portfolio of work and it's looking at which ones you're making calculated decisions. So which immersive experiences are highly likely to be profitable or marketable? And which ones am I going to work on? Those are the ones you want to start looking at. How can I get the intellectual property protections in place? How can I do my non-disclosure agreements when I meet with people and I'm expressing my ideas? And the more easy it is to knock off, the more important for your NDA to be in place, right? Because if it's something that is really difficult to replicate and you have the patent on that process to create this certain type of, you know, product, you know, it may not be as easy, right? So you always want to think about like, how do I protect myself from somebody profiting off of my idea? How do I put the legal framework in place so that if it comes to litigation, I can say, okay, you know, my patent is not pending, my patent has been approved. If you have a provisional patent, that can be, you know, also kind of good and just like potentially winning in court early on or mediating and prevailing. But you want to think about how can I put those intellectual property mechanisms in place that if it does get to court, that I'm highly likely to prevail. And a lot of artists just don't have that in place at all. They don't need it and then have a hard time litigating against somebody else who's taking their idea because they don't have a legal framework, right? We're in a legal system. The legal system has parts and you got to have the legal protections if you want to be able to benefit from that legal system, right? And you got to follow the process that goes.
So to ask you, I'm a concert photographer. I mean, it has happened to me that, for example, I went to a concert and took photos, but it was for my portfolio, and then I uploaded it to Instagram.
Yeah.
And the artist like screenshot it without my permission and posted on their Instagram.
Yeah.
So how, like at the time, I was just happy that they did that because it was like they liked it. But it's like they're benefiting from my work without giving me any credit or giving me any type of payment. So how would I approach that?
So that's an interesting concept. Concert photography, you're putting your artwork online to market yourself. Somebody else takes a screenshot and reposts without giving you credit. Or if they gave you credit, it would be to your benefit because they may have a bigger following. So you can say, okay, they copied it. One of the things to think about is whenever you're in a public place, and some issues also come up with, for example, maybe you photographed somebody that says, hey, I own my likeness. You can't photograph me. You've got to take that photo down. But you took it in a public place, so you're fine because we have no expectation of privacy. So if somebody's taking my picture in public, even though I don't like it, I'm in public, you know, like tough nuts, right? It's just the way it is. But when is somebody taking your artwork, putting it on their site, how do you show that they benefit off of it, right? So maybe there's no monetary gain to them, or even if you were to sue them, you would have to prove what your damages are. So in a lawsuit, it all comes down to damages. How were you damaged? Maybe it was your reputation that was damaged, maybe monetarily you were damaged, but how are you going to show the court that you were damaged? So how were you damaged by them taking your photo and posting? Well, maybe they generate revenue off of their social media. Maybe they use that photo and a video on YouTube, and that video generated $10,000 for them. Then you can show, okay, well, they use my photo in this video, they generate, you know, or they generate this much off of their social media accounts, and this was one of 20 postings. So per posting, this is what they would generate. That's the argument you would make, right? But it's really hard to make an argument that, well, they profited off of my photo, right? Now you can send them a cease and desist and say, hey, this is my intellectual property. You didn't give me credit. Either give me credit or take it down. And oftentimes they'll take it down, right? Or they'll say, like, sue us. And you got to figure out what you're going to do next. But a lot of art, did you message them and ask them for them to give you credit?
At the time, no, because I was just like, it was the first time that happened.
Yeah.
So I was just happy that they did that. But then I thought about it and I was like, how, like,
It's not
does
too
this work?
late because sometimes it's not even the artist that's taking your work, it's their social media person or their assistant. So
Well, my question
follows this, so
Yeah.
if you're in an event that is ticketed event, is this a public event or it's a private venue that would be stipulated and regulated by different legal arrangements?
You gotta look at the click wrap. So for example, that stuff I told you, when you buy something, like how many of you have been on a cruise? When you agree to the cruise, you agree to a whole bunch of stuff, right? When you buy a concert ticket, you agree to a whole bunch of stuff. How many of you have been to a concert? You're agreeing to a lot when you buy that ticket. You're just not reading through it all,
Right,
right?
go to events when your cell phone is confiscated and given back to you after the event because they don't want you taking photos.
Exactly. That's the only way they can really control it. But a lot of even ticketed events are generally open to the public. You argue it's an open domain, it's a public domain type of situation. But things that you want to be mindful of. So even though you didn't communicate at that point, it's not too late. If that photo is still up, to send a message and say, look, I am the author of this photo, I'm the photographer of this photo. I don't mind you using it if you give me credit. Could you please give me a photo credit? And in the future, I would love to collaborate with you and let's have a conversation. So now you're turning from an upset creative into a happy partner. You know what I'm saying? So you can also leverage a very negative situation where they didn't realize they would upset you, but now you're leveraging it for extra marketing for you. Maybe you can do a collab in the future with them, or they'll take it down and at least they're not using your work for their benefit. So you always want to also think about how can you turn a hostile situation into a beneficial situation that may benefit both. Maybe it'll benefit them because of the quality of your photography, but then they also give you credit and now you're pulling off of their social media following, which is beneficial to you as free marketing.
In which moment would you ask her to contact a lawyer to have a legal representation to kind of mitigate it?
Yeah, so I would say if you contact them and they're non-responsive or they don't want to take it down or they don't want to give you credit, at that point you can send a cease and desist. If they don't comply with that, at that point you can take legal action. But you always got to think about, is it worth it? So when it comes down to lawsuits, you can sue anybody for anything. It doesn't mean that lawsuit will go anywhere because you can file a lawsuit like I'm suing you because I don't like you and I don't like the way you looked at me this morning. So here's a lawsuit. It's a frivolous lawsuit. It will be filed in the system and it will swiftly go out of the system as a nonsense lawsuit, right? That's why when you see people that say like, oh, you know, this person's suing that person. Well, yeah, anybody can sue anybody, right? Like that can happen, but how long will that lawsuit stay? Like one interesting lawsuit to look at, which actually a friend of mine, which I'm gonna introduce you to, this attorney who's a mentor of mine when I got out of law school and when I was in law school, his client is the one and only Cardi B, who has been defamed, and this lady, like Cardi B was like, just take this stuff down. It was really nasty stuff against Cardi B. And Cardi B was like, look, like, just take it down. Just take it down, it's fine. It actually went into litigation, and this attorney is the one that handled this whole case. And I think it'd be really interesting to talk to you about what happened and how it happened. But this was somebody who's already a celebrity, who's already an amazing creative, whether you like it or not, has been very successful, very wealthy, but was being defamed online and shown in a really nasty light. And at that point, you know, you're in reputation management because you are such a creative entity and you're generating so much revenue. Is that for you, it's important to think about how do you protect your name? Because you see a lot of individuals, like for example, P. Diddy right now. I don't know how it's going to go for his career, right? Like it's looking really dicey, right? And you see, like a few months ago, these are people that are at the pinnacle of the creative experience that can make or break artists' careers. So it also comes down to, at some point, brand and reputation management. And do you want to be associated with the outlets that are putting out, you know, things either, you know, that may not be flattering or maybe just blatantly wrong or defamatory, right? So there's different levels of success as a creative and different problems that come along. Like the more money you're making, the more people will sue you because there's money to go after, right? And that doesn't mean that those situations can't be, you know, handled. Like for example, the Ed Sheeran case, where he got sued by Marvin Gaye's family off of ripping off one of his songs. And Ed Sheeran himself, in much videos on YouTube, says there are so many chords that can produce so much music today. And we cannot invent new chords outside of that. And if you look at many of the top hits today, they have similar chords in different arrangements. So at what point are we going to say, well, you stole that song or you sampled this music without? And how does it sound to a jury? Will a jury agree, right? You may have the strongest case, but your jury could be absolutely nuts. So taking the case to trial is a really big risk. Because maybe the jury doesn't like you, even though you're right, and doesn't want to favor you or doesn't want to give you the damages in the way that you see fit. So the legal world, it's not always fair and just, and it's not always perfect, and there's a high cost of entry. And that's where a lot of creatives get frustrated, is because it takes a lot of money to file for copyright, trademark protections. It takes a lot of money to litigate, right? And that's where a lot of creatives are like, this is, but sometimes in partnering with corporations, you also get the benefit of their legal team backing you up. Where if you have a licensing agreement with, Bose, or you have a licensing agreement with Coca-Cola, you better bet that they don't want their money, taken away, where their legal team can then be triggered to litigate when somebody rips off an idea that you've partnered with them. So sometimes as a creative, it makes sense to partner with really strong companies or brands that then can protect that intellectual property, because even though you're strong creative or successful creative, you may not have the capacity to spend hundreds of thousands in litigating, and legal fees add up really quickly.
Can I ask a question?
So we'll go there in
So when you're in, for example, utility, I know like you gotta go through a lawyer, right? Or is that not the case? I know like.
You don't always need a lawyer to file. It's just that when you're using a lawyer that focuses on intellectual property, that's what they do all like day in and day out. The chances of it being rejected or needing major revisions are going to be less. So you always benefit by having a lawyer that's an expert in that area. And like, I don't claim to be at all an expert in intellectual property, but I can definitely connect you with people that are. They can tell you, and there's certain intellectual property experts that are experts in music, experts in art, experts in products, where you go to them because they have seen filings, they have done these filings, and they know the likelihood of success, right? So a lot of times there are creatives that file on their own, but it becomes difficult, right? Because then there's revisions that are asked for, but it's not impossible. So you can file on your own, it's just probably going to take more time. And it may be more challenging.
And I wonder, because with the final method for a design, my understanding, if you change 10% of it, you're fine, something like that, no? So is it really worth it? I feel like if they're gonna copy, they're gonna copy. But
well, that's what you have to think about. Is it really worth it? Because if it's something that you're going to get a $50,000 grant for, and somebody rips it off in another city, like, what are you going to get by suing? You're going to have very high legal bills, right? So you have to also be practical in the sense of like, maybe it's really crappy what's happening and somebody's ripping off my idea, but if they're not making any money off of it, they're just going to be a copy, right? And then that the big brands really struggle with forgeries, and that is a multi-billion-dollar business. Because you're seeing every single day, the federal law enforcement struggles to keep up with knockoffs of purses, shoes, shirts, electronics. It's really hard to control products being ripped off. You're just trying to mitigate so that you can be profitable. Because if you make $10 or $20 million on an idea, somebody rips it off and makes one. So that's just the way that society is today, that it may not even be worth suing them because their gain is so little and you've gotten the majority of the gain. So.
And what you mentioned before, I think is very important that you say you can build up your story, and it's just harder to actually copy your part. And people will know it. But when you're sharing your story, as you mentioned, you're exposing yourself. How do you know when to actually take that step of exposing yourself, knowing the risks, but knowing that it's time to do it?
In today's society, it's very hard not to expose yourself because you have social media and you have the public that is constantly documenting what they're experiencing, right? Like, let's say, for example, you're putting together you have an idea for an installation that's going to be at the airport. what's the first thing that's gonna happen? Every single person gonna take selfies with it or take a video, upload it. So today it's really hard to keep something secret. Because as soon as you expose it to the public, it could really, get out there. And one of the things you want to think about is how am I going to benefit from that? It's going to happen. So how am I going to benefit from it? Maybe there'll be a plaque there with my story. Maybe there'll be a QR code. People can scan it and get an additional immersive experience. And how can I start building my brand and my loyalty where people will buy from me, right? Like you look at the market, for example, like the soda market, there's a lot of knockoffs to Coca-Cola and Pepsi. But, how many people are buying the knockoffs? Still millions, but Coca-Cola and Pepsi build that brand loyalty that you're either in one camp or the other, but in general, most soda buyers that are buying cola are going to buy one or the other, right? So you got to think about also for them, the knockoffs like the Shasta Soda or RC Cola or Publix Cola, when you have that knockoff, you don't get the same experience of having the original. And in today's market, it's really hard to have a knockoff that is going to stand anywhere close to the original. And you're always going to have a segment of that market that is fine with the knockoff. But at what point is that knockoff, taking significant revenue from you, where you're forced to litigate, you're forced to enforce your IP protections? Now, on the other side, we talked about IP protections from a standpoint of protecting yourselves legally, but let's talk about IP protections as an asset class. So you have your sculptures as an asset class. They're valued, you can insure against them. One of the big mistakes that people make is that they don't insure their art. They don't insure their collections. What happens if there's a fire? What if I have a studio with $1.5 million of artwork? How many of you have an art floater? An art floater is an insurance policy. And I used to work in insurance law, which is really boring. It's as boring as it sounds. But a lot of clients where I brought value coming from a family of artists is that I would go, okay, your house is insured for $2 million. How much is your art collection? Oh, well, it's, $1 million. I said, well, what's your art floater? What's that? So by having, and also that's something as a creative that you bring to your clients in saying that my art will appreciate with time, you should have an art floater. You should have an insurance policy that protects. And I've actually had my father's artwork. There was actually a situation where the painting was hanging over the fireplace. And probably none of you will know what happened to this painting. What do you think happened to the painting? No. Huh? You got what? No soot. It didn't catch on fire. It fell onto the chimney cleaning tool and punctured. And the insurance company covered, right? So that artwork was more valuable than when they bought it. And now they can come back to the artist and purchase other ones, right? So you'll never be able to fully replace. You can repair, but that piece will always have damage to it. It'll impact the value. But you got to think about also what happens if my biggest collector's, house or warehouse space or museum goes up in flames. Well, that may also be one of the best things that happen to you, because now you get to produce a whole new series of artwork. Unfortunately, the old artwork is lost, but now you have a whole new business coming, right? And you want to also think about, like, how do you protect your pieces? How do you protect your pieces against, God forbid, a fire, or God forbid, a hurricane? And a lot of artists don't think about that. They think about, like, okay, I've got my pieces, they're never going to be destroyed. They're protected, they're in this building. But what if there's a flood? Right? And also insurance for art is not expensive. But most creatives do not insure themselves. And that's one huge risk. So what do lawyers do? Lawyers help solve problems. They help mitigate risk. They always think about what can go wrong. And that's where you start thinking, like, what can go wrong? How do I protect myself? How do I protect my $1 million collection that I have, my pieces, that it's taken me 20 years to produce, or 15 or 2 years to produce? And how long will it take me to produce another collection for that level? And how will I do that if now I don't have this collection to sell anymore, which is an asset class that I own? Same thing with your intellectual property. If you have your intellectual property filings, those are things that you can sell. Musicians do a great job of doing this sometimes. Taylor Swift does a great job of protecting her intellectual property and monetizing it. certain musicians, what did they do to become really wealthy? Because they bought the intellectual property of other musicians, like the Beatles. Michael Jackson did a pretty good job of buying other people's intellectual property, knowing that that would make a lot of money. So I want you to start looking at your creative product as an asset class, right? And a lot of artists don't, and creatives don't think about it that way. So how do you protect your asset class? And that's something that should be on your mind. How do I protect my intellectual property, not only from being ripped off, but how do I protect it from being destroyed, right? Especially in the tangible world, or even in the virtual space. What happens if the digital media and the storage that it's held on is destroyed? Now I don't have access to my digital media. How do I protect that? There's got to be a way to insure it, right? There's a way to insure anything. So those are things to also start thinking. Okay, yeah, we'll go over there.
Okay.
Yeah.
I have a question. Actually, I've been in multiple lawsuits already, so I do know a little bit about the legal world.
Mhm.
My question actually is asking for most of the people here, they probably have never been in a lawsuit, never really pay for the legal fee.
Yeah.
Can you give us a few examples of in terms of cost and time? How it's gonna be like how much we're gonna expect to pay if
Sure.
someone is building an idea or product or IP or trademark. This is the fact that we are already having protection. We already having protection. We already have to prove someone's stealing our ideas or product, IP or image. How long does it take for such a lawsuit? How much we're gonna pay? And let's say they are already benefiting. In a case of the opposite party is the big company or is nobody. Because I have been the case that I was fighting with a big company, the lawsuit lasted 2 years, and I spent the thing is they owe me something like $500,000 US, and I only got the money back after 2 years, while I could have used the money way better 2 years before.
Yeah.
So in the time that I think it's the most valuable thing for me, even though I got the money back, but by the time I got the money back, I didn't need the money that urgently.
Sure. So that's one of the things you bring up in your experience. It's very common to anybody's experience with lawsuits. Lawsuits are slow, they're expensive, and it takes time to get compensated even if you win. And also, you have no idea how expensive it can be. It's very hard to say it's going to be the set amount because maybe you're in a lawsuit and the other side decides to settle. It decides to give you a check and say, look, we're done with this. We don't want to spend any more money on legal fees. We're good, right? And sometimes settling doesn't mean that you're necessarily wrong, but you're like, let me just get this. How much is it going to take care of this problem? Okay, rather than pay the attorneys and prove I'm right, they cost me $500,000. I'll give you a check for $300,000. Here you go. You go on your way. You give us a release so that you're not going to sue us on the same issue in the future, and we're all happy. So sometimes, also companies will sometimes do what's called a nuisance fee. So let's say you sue them, they didn't make much money off of your idea, maybe they made $50,000. It's not a lot of money for a big company. And maybe they say, you know what, we'll give you $40,000 and let's do a release, and that's it. For them, that $40,000 is really just to save on legal fees, which are going to be a lot more. So legal fees per hour, you're looking anywhere on the low end from a couple $100 an hour for a new attorney to thousands of dollars an hour per hour, right? And you're often paying based on what's called a retainer. So a retainer is going to be 10, 20, 30, 50,000, $100,000 that you give to the law firm that is going to sit in an account and be brought upon as needed. So when you say, hey, lawyer, I need you to make a call, that lawyer makes that call's half an hour, their billable is $2,000 an hour. They bill your retainer $1,000 and put it into their operating account, right? Lawyers make a lot of money, right? They make a lot of money. That's just the thing is that I always say in a lawsuit, who's the one that wins? The lawyers always win because they're getting paid, right? They're getting paid no matter what. They're getting paid whether they win. Oftentimes they're getting paid whether they lose. Very few lawyers will do contingency, which means that they don't get paid unless they prevail because it's too risky for them, right? And lawsuits take a long time. So for example, you file a lawsuit, you may not have a hearing for a month or 2 months. And then those hearings are then leading to a trial date. That trial date may not be till 1 or 2 years out. Let's say you prevail at trial and now you have a judgment. You got to enforce that judgment. That doesn't mean that that party that has lost against you is going to pay you immediately. So now you have to recover And what happens if you're suing a company, that company bankrupts? Now you're going into bankruptcy court as one of many people trying to get their money back. So there's many things that can go wrong in litigation. It's very risky. And in the end, if that company goes bankrupt or that company is insolvent and has no assets, you've got nothing to go after, right? So that's one of the risks we take. But in your situation, it took years, it took a long time to get justice. That's the norm. It's very rare for things to go quick in the legal system. Why? Because there's millions of cases, there's a bottleneck, there's few judges. And most judges don't want to go to trial. Why? Because they want you to settle. So the legal system has an incentive for you to settle because trials are very expensive for the government, right? And that's who's funding your judge, your bailiff, your jury, the building that's built to administer justice. So the government's perspective is we want people to settle it. Why? We want people to work it out so that they don't so heavily rely on our legal system, but the court is there for the cases that cannot be figured out. That can't, that's why a lot of judges mandate mediation. That's why they call it court order mediation. So you go to a neutral mediator that then is supposed to try to make you come to an amends. Not all mediations work out. And then you go back to the judge and say, Judge, we went to mediation. The parties were not able to come to an agreement. Then the judge will say, okay, we're going to notice it for trial. What do you do when you get noticed for trial? Is then you have to go through, all the steps to get there, evidentiary hearings, pretrial motions, and then, everything costs money along the way.
That sounds like a nightmare for artists on the market.
It is. It's a nightmare for anybody, right?
The legal fee.
Yeah.
And the time to get justice.
Yeah. And it is. And most people don't want to be in litigation. Most people don't want to be in a lawsuit. It is expensive. It is slow. At the end of the day, you may not win. But in a situation where maybe somebody took your idea and made millions of dollars and they're not willing to compensate you, you may not have any other option. And it may be just the unfortunate reality of it. But if you have your IP in line, if you are more organized and prepared, it is much less likely that you will end up in litigation. And if you have a dialogue with whoever the violator is, sometimes you can come to terms in saying, okay, I understand you took my intellectual property, here are my intellectual property protections. How can we work this out? Because you're going to incur a significant amount of legal fees. I'll incur a significant amount of legal fees. How do we find some sort of solution? And that's why the court pushes mediation so much, because it doesn't then require the court's resources to be exhausted to try to find some sort of justice. And there are situations where there has been a wrong, but it's often a breakdown in communication that makes it worse, right? That then makes it really difficult for things to get settled. And sometimes it may just be like that company is going to pay you, but they're late and you need a little bit more time. But now you're jumping the gun and wanting to litigate, and it's creating a hostile situation where now the company's starting to be reactionary. Where it may just be like being curious about like, well, why did you miss my royalty payment this month? Hey, we had a really, tough quarter. Is it possible for us to make the payment a little bit later? No problem. I don't need to sue them for that, right? I can be kind of flexible. And sometimes businesses need that flexibility because of their cash flow issues, right? So, being in communication oftentimes can solve a lot of issues in preemptively, right? But sometimes it can't.
Thank you. So I'm wondering, so when it comes to two parties, right, and legal fees, if the other party is found guilty, does that party have to cover the fees of the other party?
It depends on the jurisdiction. That's a very good question. That's what you want to have. Well, that's what you want to have a prevailing in your contracts. You want to have the prevailing party will be responsible for legal fees that result in litigation according to this contract. When you have an attorney's fees provision, if it goes to court, if you prevail, then the other party has to pay for your legal fees in addition to theirs. If you don't have that provision in your contract, that jurisdiction may not allow you to recoup your expenses. Or let's say your expenses were $300,000 in legal fees and you recover $200,000 in damages. You're out $100,000 because you didn't include that one provision in your contract. I'll give you a specific case I worked on. It was a company that painted yachts. And in South Florida, how much do you think a yacht paint job costs? Take a guess.
$50,000.
$150K. So this yacht costs $150,000 to paint, okay? $150,000, that's as much as like some people's Teslas are worth these days. And it's a lot of money, right? So to paint this yacht, $150K, this painting contracting company did not have an attorney's fees provision. Even though the firm I was working for won in federal court, the winnings were not enough to compensate for the legal fees that were incurred. And that's one of the big mistakes, is that's what actually a company, a business, a person can win or lose. So I always say, protect yourself also in your contracts two ways. Let's say, for example, if you don't have a choice of venue provision and a choice of law provision, your choice of venue should be where you are. Your choice of law should be where you are. Why? Because if I don't include those two provisions and I get sued and I get pulled into New York court, I need to pay for a New York attorney and I need to be under New York law and I need to commute to New York for that litigation. That's why I want that provision in my contracts, because maybe my corporate sponsor or person that's paying for my intellectual property, for my craft, may be in California, but I'm pulling them into my court, right? And so like I always recommend, those are the provisions you really need to have at a bare minimum in a contractual aspect, because you want to protect yourself from being dragged across the country to go. So for example, the cruise lines, we have a sponsor of a cruise line on campus. Where do you think they litigate? 2 cities in the US. Take a guess. We're in one of them. Miami. Why? Because most ships go out of Miami and Fort Lauderdale, and their legal offices are right there where the cruise terminal is. When you go into the cruise terminal, there's office buildings, that's where their lawyers are. And the federal court is right in downtown Miami. So one of the provisions when you buy your cruise ticket is that you will sue them here. No matter you came from Wisconsin or wherever. No, you're not going to take them to Wisconsin court. It all happens here. So they have a provision that it's going to be here. Maritime law is different. So their law is actually federal maritime law. It's a very separate set of law. If you're taking a cruise from Alaska, where are you going to sue them? In California. So there are other major areas, Los Angeles. They do that to protect themselves, because imagine, they get sued all the time. You have a moving platform with drunk people. You're going to get sued a lot, right? So cruise lines get sued a lot. What they want to do is they want to limit their exposure. It's not about, you can never protect yourself 100%, right? No matter how careful you are, let's say as a driver, you can be the most careful driver. There's so many things. A tree limb could fall and hit your car, causing you to crash. A cat can run in front of your car. You could blow a tire on the highway and lose control of your vehicle. Like there's so many factors that can influence it. So as a creative, you want to mitigate what happens if my property gets destroyed? What happens if my property is stolen? Most creatives don't think about, somebody could break into my studio and steal my artwork. What am I going to do? If I don't have an insurance policy, what's my recourse? All my life's, right? So those are things you did not think about probably before today, but it's not something you think about from an angle of fear, but an angle of security. It's like, okay, now I'm aware, and I have the insurance floater cover my property, where if it's stolen, I'm going to get compensated for it. If it's destroyed, I'm going to get compensated for it. If I'm going to be in litigation, at least my contract has my litigation here, where I can control my legal expense, where I can control my venue, where I can control what court I'm in, where I can control how far I need to go. So those are all things I wanted to make you aware of, because I'm not here to be the IP expert. That's going to be somebody else. But I'm the one that is here to start opening your eyes to like, what can I do to bring some more protections? So like, you're not going to have all of it. You never do. No creative, no business owner has everything. But if you can start implementing pieces that protect you over somebody else, then you start to really have this safety net of like, you know, something catastrophic happens, at least I know I can be compensated for my artwork, that I'm not destitute, and my creative, you know, imagine having to start all over with like, if you're a sculptor, you have 50 pieces, and now those pieces are destroyed. Like you lost a lot of work and a lot of value, right? And you want to be compensated for that value. So there's things just we'll go here then.
So one thing that's great is that we don't think about is money.
Yeah.
And law, right? We're too eager to just get beyond the good things with life, right? So
absolutely.
one of the things that maybe you can speak more about, what the things think about when you start to, you know, as everyone they will do, start to deal with clients and maybe small companies, one company, and that is Amazon. And they give you these contracts as a contract, right? As all most people have the contract, work jobs. And you get all these specifications of contract that deal with a lot of these things like IP and, you know, intellectual property, things that you may think of before you work that, after you work that, right? And I think a lot of creators don't read and not used to not reading.
And you sign
So
it.
where I work, you know, now I'll go back and, you know, I'm not afraid of going back and be like, this, I don't like this, and it's you guys change it.
Yeah, you gotta read, that's a very good point. You have to read what you're signing when it comes to, if it's your iPhone, it doesn't matter. You know, Apple's whatever, you just gotta agree to it because you want your iPhone to work. But when it comes to your contract with a company, you gotta be very careful in reading what are those provisions, right? And a lot of them are pretty straightforward, some may not be, but you actually have the opportunity to mark up and change certain provisions. So you can cross out things you don't agree with, you can mark up the contract, you can revise the contract and say, listen, there's a few things that are of concern, mostly subsections 4, 7, and 8. I want to make these modifications. You send it back. Maybe their attorney is going to want to make some other modifications, and then at least you're coming to some consensus. Maybe that company says, look, take it or leave it. If you don't like it the way that it is, we'll find another artist to work with. And then at that point, you gotta be ready to deal with whatever you agreed to in that contract.
Yeah,
And,
how do you deal with that?
well, here's the thing. So let's say, for example, you sign a contract, you didn't read it, the onus is on you, you didn't read it, you agreed to it. And you've got to comply with whatever you agreed with that contract, unless you, often a lot of contracts get breached in certain ways. And it just depends, is that breach material? Is it significant? Is it insignificant to what you have agreed to? But obviously don't sign something that you haven't reviewed, or at least haven't had an attorney review on your behalf. Or even maybe another creative that may be giving you a different perspective, right? Say, hey, this is a contract, I've read it over. I think it's fine. Would you be willing to review it to see from your perspective? Because the provisions often are valuable. You can often make certain addendums or changes to contracts. But you also don't want to just blindly be signing contracts because that contract may have an exclusivity clause. And you're like, I don't want to exclusively work with you, right?
So that's the one thing that I brought into the past is proceeding where, you know, I'm making sign something like depend on what it is. But the other one that I've seen maybe in the past, 5 years is IP ownership, meaning that maybe something that says whatever intellectual property you have while you're working here is owned by X. But whatever intellectual property or inventions or things that you come up with while working at the studio or working at this company, even if it's after hours, still can belong to the company.
And that's where you want to clarify, like any production within, usually if there's a company paying you for your time and your creativity, whatever you're producing in that period of time can be theirs. But you can also have a lot of technology today has timestamps on when you're producing it, and you can show that. And you can also make your own provision and say, all creative production by myself after 6 p.m. Monday through Friday and all day Saturday and Sunday, I want to retain, intellectual property too. I also got to be able to prove, if you're dealing in the digital space, it's easier to prove when did you work on that than if you're dealing in the sculpture space. Like, how can I say that I worked on the sculpture, right? So that's something you also want to think about, and you also want to say, like, within the scope of the contract, like, how do you limit the contract, from what they're giving you? Because of course they're going to want the most wide contract and covering as much as possible to protect themselves. But you may say limited exclusively to production based on video editing, or production based on, printmaking, or production made on logo designs or t-shirt designs or whatever. So you can also limit certain scopes of what intellectual property are they going to own. Or you can create a partnership where you say, like, any intellectual property created, I will retain a 25%, share. They will maintain a 75% share. That way they run with it and they make a lot of money and they market it. At least you're retaining some ownership in intellectual property.
Last question for you,
Absolutely.
which is how has technology, in particular AI, recently, as you've been practicing for a long time in your field, and long before AI became common knowledge and factor in understanding how the economy is being changed as we sit here. Entities like LegalZoom and other entities. So for startups, small businesses, artists, what are the advantages of using initially like online tools, do-it-yourself tools, and then combining them with lawyers later? And how are lawyers like you affected by this horizon, that's changing the way the legal profession is? Because a lot of the legal profession is procedural, and a lot of these contracts are, essentially algorithms. They're just sort of like a set of rules and terms and conditions. And so how do you see this affecting the way you protect your business?
So, for example,
And practice your business.
yeah, the way that AI is going to impact the legal world is that, companies like LegalZoom or do-it-yourself websites are good in the sense of that they give a wider audience the opportunity to a certain level of protection. But the problem is that the public doesn't understand a lot of nuances of law. So, for example, what I see a lot of today is, well, I got, my will done for $29.99 online, which is great. Okay, you have a will. But what does that mean? Most people think that, okay, because my will is done, as soon as I die, there will be an attorney that reads my will and distributes my property. It's not the way it works. You still have to probate it because it's not in a trust. And there's a much bigger benefit to putting all your assets in a trust. Why? Because the trust can then allocate it to whoever you want, and you don't have the tax implications. Because the trust is the owner. When you put all your assets in a trust, you don't own it anymore legally, but you're the trustee, and you legally own the trust. So it's kind of a concept that's a little bit abstract, but in the legal system, you're using the legal framework to avoid inheritance tax, right? And a will is only your desire, but it doesn't trigger transfer. It just triggers your desire. And that's where you have an issue, like with Aretha Franklin. How many of you remember Aretha Franklin, the famous musician? She had two written wills, one in a sofa that she used to sit in, and one in a cupboard in the kitchen. So which one is valid? It's the one that's going to be the most temporally recent, right? So it's the latest one that she did, right? And that was the one that they were able to figure out this is the most recent. When you have a new will, all old wills are no longer valid, right? As long as they're valid executed wills, or in that sense, like the way that she did it was similar. So it's going to be that what's prevailing. But when it comes to AI is taking a lot of the processes and streamlining them. It's helping in a lot of ways. It'll probably reduce the amount of paralegals and assistants that are hired by law firms because they're not going to be as needed. That's also automating call responses where, you may not have a receptionist and they'd be like, hey, thank you for calling this law firm. Please let me know which department you want to talk to or which attorney you want to talk to. So it will reduce a lot of the labor requirements, which could bring down costs in certain ways. But where attorneys will be very valuable is in litigating cases and fixing problems that the AI created. Because the AI is only as good as the inputs. But when you put the wrong inputs in because you don't understand those areas of law, now oftentimes, like when I tell students, draft your own NDA, like, yeah, they draft the NDA, but there's certain things that they're missing that they're not thinking about, right? So it may make sense to draft the first copy and then have an attorney look it over and you pay a few $100s to say, okay, what else am I missing? What else do I need to include to further protect yourself, right? And in the future, I think that AI will help people get that basic legal protection or at least that foundation of what they should have. But as things are changing, we also need to think about how am I going to be prepared for litigation, or what are outside factors that I'm thinking about, or am I using the right documents? And are those documents still valid in that jurisdiction? Because things are going to be changing. So are lawyers ever going to be out of business? I don't know. I hope not, because if lawyers are out of business, probably a lot of us will be out of business, right? So, and certain creative sectors have, like, the negotiations that happen with the movie industry to exclude AI in certain dimensions. That could also happen where perhaps AI generated documents in certain aspects may not be, this is speculation, may not be able to be, utilized in certain aspects because of the problems that they create. Because the AI is only as good as the inputs. Now, the problem with open AI is that you deal with confidentiality issues. And that's where the legal field is challenging itself to come up with closed AI systems that can help clients have less expense, but that protect their clients' confidentiality, intellectual property. Because if you plug in your intellectual property to ChatGPT or OpenAI or Copilot, it is using your information to then also work on other people's creative processes, and you just released your data into a public domain that now could also influence how it gives other people ideas and how it generates solutions for them. So you also have to be careful with AI because it's so unregulated, it's so novel. The legal market and the legal industry is always slow to adjust the technologies. So it's always lagging behind, but they're, like the Florida Bar, for example, has its own committee on AI. And the legal education through ABA is always looking at like how will AI influence how lawyers are educated, how lawyers work, what it means for the industry. I think this, so it's good and bad, right? It's good and bad because you may be able to be helped with a certain level of contract, and a certain level, like the mundaneness of the law can be pulled out, but also are you doing the right thing? Are you including everything you need for your specific situation? That's where the challenge is.